At the trial, my wife arrived with her lawyer 2 years of preparation and a neurologist's report affirming that I was losing my mind. She smiled triumphantly, certain that everything was over. The judge looked at me and said, "If this evaluation stands, you will lose the legal rights to your own life." I turned to my lawyer and said, "Play it right now." Shadi. 4 seconds after the recording started playing, my wife stood up abruptly. "Stop, turn it off immediately. Thank you for being here, it means more than you know. Tell me in the comments. Where are you watching from, country, city? I want to know who's in this room with me." Note: this story contains fictional elements for entertainment and educational purposes. Names and settings are coincidental, but the lesson inside is one I hope stays with you. That afternoon in the courtroom on December 12, 2023, I sat there looking like a fragile old man. 61 years old, gray at the temples, moving carefully, the way men my age are supposed to move. To anyone who didn't know me, and several people in that room were counting on not knowing me, that's exactly what I appeared to be. But if you want to understand what happened in that courtroom, the story doesn't begin there. It begins on a warm evening in May of 2012 at a charity gala I almost didn't attend. I'm telling you this from a small rented house on the east side of Hargrove on Christmas morning of 2024. There's a 10-year-old asleep in the next room, and a dog who has no respect for anyone's schedule pressing his cold nose against my knee. Outside, the neighborhood holds the particular quiet that only comes with new snow. My coffee has gone cold, and I have a story I've been waiting 12 months to tell properly. My name is Arthur Weston. For 20 years, that name meant software. It meant contracts and early mornings and airports and boardrooms and a company I built not from family money or venture capital, but from 12 consecutive years of sleeping less than 5 hours a night alone in a rented office with a whiteboard and a problem I believed was worth solving. I started in 2001 above a dry cleaner in downtown Hargrove with 2 employees and a single client who paid us late. What I was building was infrastructure software, the quiet kind, the kind that no one mentions at dinner parties, but that runs inside the systems of companies large enough to need it and too busy to build it themselves. By 2010, we had 240 business clients across 18 states. By 2020, we had built enough to matter. What I didn't have was a life that looked like anything other than work. I ate dinner alone in more cities than I can name. I missed every company holiday party because I was always on a plane somewhere else. I am not asking for sympathy. I made those choices, and I understood their cost. But there is a specific kind of loneliness that comes with building something successful, a loneliness that doesn't announce itself with sadness, but with a slow, ambient absence. You look up one day and realize you haven't had a real conversation in months, a real one. Not a meeting, not a negotiation, a conversation. Before 2013, I was not in a single family photograph. There was no family to be in one. My sister Maggie called in early May of 2012 while I was on a layover in Denver with 2 hours to kill. She had 3 points prepared, which was how Maggie operated. First, I hadn't attended a non-professional social event in 14 months. Second, the Hargrove Community Foundation's annual gala had a table with my name on it paid for reserved and skipped 3 years running. Third, Arthur, you spend money on everything except being present. She paused the way she always did when she wanted the words to land. This year you're going. I almost didn't. The event was held in Hargrove's grand ballroom, the kind of room with actual columns and waiters in white gloves and donors who already knew each other well enough to have favorite tables. I arrived late enough to skip the receiving line, found a position near the windows with a glass of sparkling water, and began calculating 90 minutes, 2 board members, 1 silent auction bid. Exit. I had worked that sequence enough times to run it without thinking. I was 15 minutes in when she walked up to the wrong table, and asked if the chair beside me was taken. Her name was Diana Calloway. 27 years old, she said real estate. Her colleague had disappeared into another conversation the moment they arrived, and she was looking for somewhere reasonable to stand. She wore a dark green blazer over a simple blouse, low heels, no statement jewelry. She wasn't working the room. She was observing it, which was something different entirely. We started talking because the alternative was silence, and Diana Calloway did not appear to do silence. She asked what I did. I gave the version I always gave at events like this: software, infrastructure, enterprise clients. Most people nodded and pivoted to someone else. She didn't pivot. She asked what problem I actually solved. I told her. She asked why that problem was worth solving over the adjacent ones. I told her more than I'd intended. She pushed back on one assumption, something about scalability curves versus adoption rates, and she was right to push back. I said so. She didn't seem surprised. We talked for close to 2 hours. Technology and what it actually changed versus what it promised to change. Hargrove, a city she had grown up in and I had chosen, and we each had different reasons to stay. Books which she had strong opinions about, specific and unapologetic. At some point the formal program began and we moved our conversation to chairs, lowering our voices around the speeches without actually stopping. At 10:40 I noticed I hadn't checked my phone once. I drove home at 11. The highway was quiet with the particular emptiness of a late weeknight, and somewhere on that drive, I couldn't say exactly when I noticed I was not thinking about anything work-related. No contracts, no client problems, no open decisions waiting on my desk. Just the road and the city lights and the strange and unfamiliar sensation of having spent 2 hours talking with someone who was actually listening. At 50 years old, that shouldn't have been remarkable. But it was. I had spent 2 decades as the most capable person in most rooms I entered, and one of the loneliest. I had been seen as a CEO, as a checkbook, as a competitor, as a name worth collecting at a gala. I had not been seen simply as a person. Diana Calloway had asked me what problem I was solving, as if the answer genuinely mattered, as if I mattered independent of whatever I'd built. I drove home with the lights of Hargrove fading in my mirrors, and understood quietly that I hadn't known I was hungry for that until I'd already had it. By November of the following year, Diana Calloway would become Diana Weston. And the woman standing beside me at that altar seemed like everything I had ever built toward. I believed that completely. For a long time, for longer than I should have, I believed it completely. Our wedding was small by design, 27 guests in a garden on the eastern edge of Hargrove on a Saturday in November, when the air smelled like wood smoke and the leaves had gone gold. My sister Maggie cried during the vows. My mother Eleanor, 78 years old and sharp as a blade, held my hand at the reception and whispered, "She's wonderful, Arthur." I thought she was right. We had decided against a large ceremony because neither of us wanted to perform one. Diana had no interest in spectacle, and I had attended enough events where the production swallowed the occasion whole to know I didn't either. So we kept it to the people who actually mattered: family, a handful of friends, a very good caterer, and Maggie crying every 10 minutes, regardless of the size. It was the right kind of day. For a long time after I held on to that. Diana ran her real estate practice from an office on Midtown Circle, and for the first 6 years of our marriage, we fell into a rhythm that suited us both. I left before she woke up. She was usually home before I got back. On weekends, we had enough of each other to remember why we'd made the decision in the first place. We were both people who understood what it cost to build something. She respected that in me, and I respected it in her. More than I had expected to. Then in November of 2014, Lily arrived. She came 3 days early on a Tuesday morning, which felt exactly right for someone who would spend the next 9 years refusing to wait on anyone else's schedule. 7 pounds, 2 ounces. She screamed for 45 seconds, and then stopped and looked around the delivery room with an expression of complete, unhurried assessment, as though she was already cataloging what she had to work with. I held her for the first time against my chest, and I sat with that weight, and I thought, this is what it was for. Not the company, not the contracts or the early flights or the boardrooms or the 20 years of building something from nothing. This exact weight in this exact moment. I had constructed a great many things in my life. Lily was not something I constructed. She was something that arrived and rearranged every priority I held without asking permission, and I was grateful for every bit of the rearrangement. The years between 2015 and 2019 were by every measure that actually counted the best of my life. I am not walking that back. Lily grew into someone recognizable. Stubborn in the precise sense she didn't change her position without a genuine reason, which meant she couldn't be pushed, only persuaded. Curious in the sense that she asked follow-up questions when most children her age had already moved on to the next thing. She wanted to understand not just what happened, but why. I saw myself in that. Diana noticed it too, and she said so half-smiling like a mild warning. Diana was a good mother in those years. I want to be careful and precise about that, because what came later creates an undertow that can pull the entire record backward, and that revision would be dishonest. From the time Lily was old enough to sit still for a story, Diana read to her every single night. Every night from 2014 through 2018. She didn't hand it off when she was tired. She didn't skip it when the day had been long. She sat on the edge of that bed and read until Lily's breathing slowed, then closed the book quietly and came downstairs. In the fall of 2018, my mother Eleanor needed a hip replacement. She was 83, sharp as ever, but physically slower and more resistant to accepting help than anyone I have ever encountered. Diana drove her to Hargrove General at 6 in the morning on surgery day and stayed in the waiting room for 6 hours while I was on a flight back from a contract meeting in Boston that could not be moved. No one asked Diana to stay. Eleanor certainly didn't ask. Asking wasn't something Eleanor did. Diana stayed anyway. When I landed and called to check in, Eleanor got on the phone before Diana could hand it over properly. "That wife of yours has been sitting here the whole time," she said, in the tone she used when she was impressed, but didn't intend to make it easy. "You'd better deserve it. I've spent a long time since then, trying to honestly answer the question that comes with. All of this was any of it. Real, the evening's reading. The 6 hours in a hospital waiting room, was that Diana, or was it something that held together long enough to matter before something else came along to replace it? I don't know. That is the truthful answer. The Diana who stayed with my mother without being asked that person existed. I watched her do it. Whatever she chose later, whatever calculation came later, the woman in that waiting room on that morning was not performing. Whether that was who Diana genuinely was, or only who Diana believed she was before someone sat down with her and offered a different version of herself, I can't tell you. I've turned that question over for months now, and I think the most honest thing I can say is that I'm not certain it has a clean answer. There is something I should tell you about the beginning of our marriage that I didn't register clearly at the time. Before the wedding, Frank Harmon, my attorney of 12 years, a man whose judgment I trusted completely, drafted a prenuptial agreement. Diana reviewed it with her own counsel, asked 2 clarifying questions, and signed it without making it an issue. I read that as straightforwardness. I respected it. What I didn't think through carefully enough was what that document meant for her options a decade later, not in an abstract sense, but arithmetically. I didn't consider what it would look like to someone who one day sat down and calculated precisely the difference between what a divorce settlement would yield under those terms and what a different kind of arrangement might produce instead. That calculation, it turns out, matters considerably to the rest of this story. In the spring of 2020, I signed the paperwork to sell the company for $85 million. It took 4 hours and several rooms of attorneys. I held a pen that felt lighter than it should have given what it represented. I had spent 2 decades building something, and I was signing it away, not because I had failed, but because it was finished. Done. Enough. And because there was something else I had been meaning to get around to for a long time, and I had finally run out of reasonable excuses not to. I thought about the mornings. Driving Lily to school, she was 5, just starting kindergarten, and being the one to actually do it every day, instead of hearing about it secondhand from a departure lounge. I thought about dinners we would cook together and Christmases that wouldn't have to end at the airport. I thought about time and what I would finally do with it. Holding that pen, I believed we had all earned what was coming next. Retirement was supposed to give me more time with the people I loved. What none of us could have predicted was how differently each of us would experience that change and what that difference would eventually cost. In the first 6 months after I sold the company, I drove Lily to school every morning. That was new. I had spent 17 years building something and missed 17 years of school mornings in the process. I was trying to get some of that back. What I didn't see, what I wasn't prepared to see, was that my being home had quietly changed the geometry of everything else. Those first months were genuinely good. I want to acknowledge that, honestly, the same way I tried to be honest about what came before. I cooked dinner most evenings badly to start, then adequately, which for someone who had lived on airport food and hotel room service for 2 decades, counted as a genuine improvement. I read in the garden on the long, unhurried afternoons. I had always promised myself I would eventually get around to having. I drove Lily to Hargrove Elementary every morning, walked her to the gate, and waited through the 3 separate goodbyes she required before she'd actually go through it, because the first 2 never quite resolved the matter to her satisfaction. I had missed those mornings in the specific sense, not abstractly, in the particular irretrievable sense of not being there while each one was actually happening. Now I was there. Catching up felt like exactly the right word for what I was doing. Diana was busy. She had a full client roster, a practice she'd built methodically through the years I was traveling, and a professional identity that had not required my presence to sustain itself. That was fine. We had both built independent lives before we built a shared one, and my retiring did not dissolve that fact. I respected the work she had put into her own career. I intended to stay out of the way of it. What I was slower to understand was the shift in the household's center of gravity. For 17 years, Diana had run everything the house required. She was the constant, the school logistics, the weekend plans, the invisible structure that makes a family's daily life function without anyone recording the effort behind it. She had been the one who was always present. Now I was the one who was always present, and the space that had been entirely hers had changed shape. She was 37 years old, still climbing professionally, and suddenly her husband was home. Every single day. I understand that dynamic clearly now. At the time I noticed it without naming it, which is not the same as understanding it. The changes came one at a time, and each one had a reasonable explanation within reach. Her phone appeared face down when I entered rooms she'd been sitting in with it. Not every time, but consistently enough that I registered it and then filed it away under nothing in particular. Her client appointments started ending later in the evenings, 9 o'clock, sometimes past 10. She came home in November wearing a perfume I hadn't encountered before, and I didn't remark on it. A gym membership appeared in January without prior mention. Each item individually meant nothing. Together I kept them in a part of my mind I'd decided not to examine too carefully. In February of 2021, Diana came back from a medical real estate conference at the downtown convention center. Over dinner, she mentioned a doctor she'd ended up in conversation with between sessions, Nathan Cole, a neurologist. Exceptionally sharp, she said. A good professional contact for that sector of the market. She said it in the tone people use when passing along an unremarkable professional note, the kind that fills in 5 seconds of dinner conversation and then moves on. She said his name once, and then she never said it again. The silence after a name is louder than the name itself. I've learned that since. Through spring and into summer, the accumulation continued without announcing itself. A car I didn't recognize sat at the far end of our street on 2 separate afternoons, when I'd gone out on errands there, when I left gone an hour later. In June, Lily mentioned at dinner that her mother's doctor friend had sent a message about a house with a good yard. She said it the way children say things that have simply become part of the daily furniture of their lives, unremarkably, between bites already moving on to the next thought. I passed the salad. I kept the item. In October, I came home 30 minutes earlier than I'd said I would. My key was in the lock when I heard Diana's voice shift inside the house, not the words, just the register of it. The specific change in pace and cadence that happens when someone becomes aware of being overheard. By the time the door was fully open, she was standing in the kitchen phone at her side, expression composed. "Work call," she said. "Ran long." I said I understood, hung my keys on the hook, and went upstairs. She was probably telling the truth. I held on to that for 3 weeks. Thanksgiving was at my mother's house the way it had always been. Eleanor had lived 20 minutes east for 41 years, in a house that operated entirely on its own quiet logic, and the arrangement had never needed planning. We simply arrived. She had cooked more than was necessary, and we ate at the long dining table she had stripped and refinished more times than any of us had ever counted. Diana was good that evening. She helped in the kitchen without making it into a gesture, and she spent real time with Eleanor talking, asking questions, actually listening, which mattered, because my mother had no patience for performed attention and could recognize it from across a room. She made Lily laugh twice at the table, given how seriously Lily approached the whole enterprise of eating a meal that was not nothing. After the plates were cleared and Lily had settled in the living room, Eleanor and I washed up the way we always had. She washed, I dried, almost no conversation, because the task didn't require any. I was expecting a verdict on the pie. What she said instead, quietly, still facing the sink, "She looks at you differently lately, Arthur, like she's counting something." I kept working the towel. "You worry too much, Mother." Eleanor set the dish into the rack. "I worry precisely enough." She left it there. Eleanor said the necessary thing once and did not repeat herself. She understood that the person she was addressing had already heard her. I drove home with Lily asleep in the back seat and Diana quiet beside me, and I turned those 2 words over the entire drive. Counting what? I had spent 4 decades reading people across negotiating tables in closing rooms, in meetings where the conversation that mattered was always running beneath the conversation being held out loud. I had built a company on understanding what someone actually wanted before they had said it plainly. And my mother, a woman who in my entire memory had never raised a concern she hadn't first thought all the way through, not once. Not about anyone had just said something she did not say carelessly. The answer, when it finally arrived, did not come from me or from anyone with particular reason to be watching. It came from a 7-year-old girl with pasta sauce on her chin, who was simply making conversation at the dinner table. Here is something I haven't admitted to many people for 3 months after my mother's words followed me home from Thanksgiving. I made a deliberate choice not to know. That may sound like cowardice. Perhaps it was. But I think there is something particular about being 60 years old and watching the architecture of your life begin to shift, something that makes you want to, for just a little longer, to believe the foundation is still solid. Diana was attentive in those winter months, in a way that was easy to receive as concern. She asked after my health more frequently than she had in years, whether I was sleeping well, whether I'd noticed any changes in my energy. Once over breakfast in early November, she asked casually whether I'd been forgetting things lately. Nothing in particular, she said, just something she'd picked up on. I told her I felt fine. I told her Dr. Ellis, my physician of 20 years, a man who had the old-fashioned habit of actually knowing his patients, would have mentioned something if there were cause for concern. She nodded, moved on. What I understand now, looking back at those conversations, is what they were actually for. Every question about my memory, my energy, my cognitive sharpness, none of it was caring. It was documentation. But that piece of the story belongs further along, and I'll tell it properly when we get there. The new doctor suggestion came in November. A specialist, Diana said, someone a friend had recommended. Someone who took a different approach to what she called proactive health management for men at this stage of life. She said it gently, without pressure. I said I'd been with Dr. Ellis for 20 years and had no reason to change. She said, of course, and dropped it immediately. The dropping it bothered me more than the suggestion had. A worried spouse presses asks, again finds another angle. A person who needs a specific answer and can afford to wait simply files the first refusal and moves on. This is the place in the story where I need to give you a number, because without it, what came next makes no rational sense. A divorce, given the prenuptial agreement Frank Harmon had drafted before our wedding, would have yielded Diana roughly $3 to $4 million after attorneys and years of litigation. That is not a small amount, but it is also not $47 million. Full legal guardianship over an estate of that size, the court granted authority to manage transfer and make financial decisions on behalf of someone declared no longer capable of making them for themselves, is not a settlement. It is the estate itself. It is everything, without the years of legal combat, and without the ceiling that a prenuptial agreement places on what a spouse can walk away with. I understand now why someone would find that worth the risk. Whether Diana fully grasped what she was agreeing to when she first said yes is a question I've stopped trying to answer. But the arithmetic is not complicated, and someone had clearly done it. In December, Maggie called and asked if I wanted to get coffee. She had a way of phrasing invitations that made it understood they weren't really questions. We met at a place on Alderton Street we'd been going to since she moved back to Hargrove in 2008. Corner table because she liked to see the door. We talked about nothing of consequence for a few minutes. Then she put her cup down and looked at me the way she did when she had decided something was going to be said. Something is wrong at home. Arthur, I can see it. Lily can feel it even if she doesn't have the words for it yet. You need to stop pretending you can't see it too. She said it without drama, without performance. The tone she had always used when she had thought something through completely before saying it out loud. Everything is fine, Maggie. She looked at me for a moment. Okay. And she didn't say it again. She picked up her cup, and we moved to something else, and that was the end of it. We both understood what had just happened. I had said something that wasn't true. She had decided once was enough. Neither of us needed to work through it out loud. I drove home turning over the specific way she'd said, okay. Not doubtful, not wounded. Just, I've done what I can, and the rest belongs to you. January was cold that year, and the house at night had settled into a stillness that wasn't quite comfortable. Not the easy quiet of a household at rest, but the narrower kind that fills in where conversation used to be. I was coming back down the hallway past the guest room late one evening when I heard it through the open gap of the door, a man's voice, low and unhurried mid-sentence. One beat, before Diana looked up and saw me standing there, one beat of a voice I didn't recognize. And then the shift, the adjustment, the way a room changes when it becomes aware of a witness. She looked up. "Difficult client," she said. "Sorry." I said, "Take your time," and walked to our bedroom. I lay down in the dark, without turning on the light, and stayed there for a long time. What happened in that room was not grief. I want to be precise about that. It was inventory, the same cold accounting I had done in 100 board meetings when a deal had turned, and I needed to understand exactly where I stood before deciding what to do next. I went through the list I'd been building since the previous spring. The phone, the hours, the name said once and then retired, the health questions, The doctor's suggestion dropped without argument. A man's voice at 11 at night in the guest room of my own house. I had negotiated enough contracts to recognize the sensation of being on the wrong side of one. The patient positioning. The management of what you're permitted to know. The careful construction of a version of events designed for a specific audience. I have been on the wrong side of this one, I said to the ceiling for a very long time. It was a Tuesday in February. Lily was 7 years old, with pasta sauce on her chin, and that specific expression she carried when she was about to say something she considered completely unremarkable, which was in this case going to stop time. Dinner had been the way our dinners had been for months. Lily providing most of the energy, Diana responding at appropriate intervals, while the phone in her lap did most of her thinking for her, and me managing the kind of performance I'd had enough practice at to keep convincing. We were eating pasta. Lily was explaining something complicated about a disagreement with a friend at school that afternoon, the kind that required full coverage of all parties' motivations, which Lily always provided because she didn't believe in incomplete accounts. Diana said in the right places. I watched her do it, the small automatic responses that filled in for actual attention. She was not hearing a word. Then Lily looked up in the easy, unhurried way of a child changing subjects because the first one had simply run its course. Daddy. Why does Uncle Nathan know where you keep your important papers? The gray cabinet. The tall one in your office. He had it open last Thursday when you were at Dr. Ellis's. I set my fork down. The motion was unhurried. The expression on my face did not change. In 40 years of negotiations where the stakes were high and the table separated people who needed to not know what the other person was thinking, I had learned to let information land without letting anyone see it land. That skill had carried me through boardrooms and closing rooms and deals I'd needed to outlast someone to win. I used it now. That's interesting, Bug. Thank you for telling me. I picked up my fork. I took a bite. I looked across the table to Diana. She was looking at her plate, not in the distracted way of someone mid-thought or the habitual way of someone cutting food. She was looking at it with the fixed, deliberate attention of someone managing what her face was doing. And she was not quite managing it. A beat too long. 1 or 2 seconds past the natural pause of a woman hearing something that contained no information she didn't already have. She did not look up. Lily moved on. There was a third party in the school disagreement, whose role she hadn't fully accounted for in the first telling, and she corrected the record with the same thorough energy she'd brought to the original. I listened. I responded. I ate. Inside, I was doing something different. The man Lily called Uncle Nathan, a title she used because someone had introduced him to her exactly that way, because that was how it had been framed for her, as something ordinary and familiar and unremarkable had been in my private home office. In the room where I kept the trust documents, the property deeds, the account structures, the full architecture of everything I owned. The gray cabinet was locked. Diana had a key because she'd needed one years ago, when I was traveling during a medical situation and certain documents had to be accessible. I had given her the key without thinking about it. I had never asked for it back. Nathan Cole, the neurologist from the February conference, the name said once and never again, had been standing at my filing cabinet with it open on a Thursday afternoon when I was at my doctor's appointment. And Lily had told me about it the way she told me about what she had for lunch. Because to her it was that kind of thing. Because someone had allowed it to become that kind of thing. Dinner ended. Lily asked to be excused, disappeared to scrub the pasta sauce off her chin, and negotiated her way through the Tuesday bath. Diana and I carried the plates to the kitchen. I ran the water and washed. She dried. We were 2 people in a small kitchen with enough space for a full conversation, and we did not have one. Not a word about the table. Not a word about anything. I handed her the last bowl. She took it, folded her towel on the counter, said she was tired. Good night. Good night, I said. I stood at the sink and listened to her footsteps on the stairs. At 11, when the house had gone quiet and the sounds from upstairs had settled into the long, unbroken rhythm of sleep, I took out my phone. I opened the Notes application and created a file locked with a 6-digit code I had not used for anything else. And I typed exactly what Lily had said. Every word. In sequence. I read it back once, then again. The gray cabinet. The tall one in your office. Last Thursday when you were at Dr. Ellis's. I read it a third time and thought about what each word required. I went to bed at midnight. I did not sleep. At 5 in the morning, I was still on my back in the dark, and I had been there long enough to have worked through all of it not with emotion, but with the same cold procedural clarity I had applied to every decision that had ever actually mattered. What had been done, what it meant, what it made necessary. I had spent 22 months looking the other way. That ended on a Tuesday in February over dinner, because a 7-year-old told the truth about something no one had thought to teach her to keep quiet. Children don't learn which things are secrets until adults sit down and explain that some things need to stay hidden. No one had explained it to Lily, so she had simply told me between bites, as a point of minor curiosity. By the time the breathing in the next room had gone slow, and even I had stopped being the man who extends his wife the benefit of the doubt, my 7-year-old daughter had just told me in the language of a child who did not know she was providing evidence that a man I had met twice at social events had been standing in my locked private office, with my filing cabinet open while I was gone, and she had considered it unremarkable. I was finished asking whether something was wrong. The only question left was how wrong and what I was going to do about it completely and without mistakes. Before Diana woke up the following morning, I made 2 phone calls. The first lasted 4 minutes. The second lasted 7. I told both people the same thing: find everything, find it carefully, and make sure no one knows you're looking. What they found over the following weeks would turn out to be considerably larger than an affair. I want to be clear about the order of things, because it matters. I did not go looking for something I could use against Diana. I went looking for the truth, because after what Lily had said at the dinner table, I realized I had spent the better part of 2 years navigating a situation I did not fully understand, and I needed to understand it completely before I made any decision at all. Carl Briggs ran a small investigative practice out of a second-floor office on Commerce Street, east side of downtown. I found him through a former business contact, someone who had used his services during a partnership dispute a few years back, and told me 2 things: that Carl was thorough, and that he did not talk about his clients. Those were the only 2 qualifications that mattered. I gave him the outline without giving him names. A man I believed my wife had been involved with. Some indication that he had been inside my home, specifically in my private office. I needed documentation, photographs, locations, dates, the kind of record that could not be misread. I waited until early April before making contact. I needed the reference confirmed and the initial picture clear enough to know what I was asking him to find. The 3 weeks that followed were the most precisely managed performance of my life. I sat across from Diana at breakfast every morning. I waved Lily off to school. I read on the back porch on the afternoons when the weather held, and appeared to be exactly what Diana needed me to appear to be: a retired man with nowhere urgent to be and nothing pressing on his mind. On mornings when she looked tired, I had her coffee ready at 8. I asked about her listings. I listened when she answered. I gave her nothing to work with. Carl called on a Saturday morning in late April. I was in the garden with a book I had read the same page of 3 times without retaining a word. He said, "I can bring it to you, or you can come to my office. Your choice." I said I would come to him. I drove downtown, took the stairs, and sat across from his desk. There was a brown envelope on the surface between us, thick enough to hold 3 weeks of work. He slid it across and said nothing. I opened it. Photographs time-stamped and geolocated Nathan Cole's apartment building in the Midtown district, captured on 4 separate visits. 2 hotels, both within 30 minutes of the city, both documented across multiple dates. A restaurant I had driven past on the western side of the suburbs without ever having reason to stop. Names on reservations, lobby footage, parking timestamps, check-in records Carl had obtained through channels I did not ask about. 3 weeks of material. Clear, sequential, and not open to interpretation. I looked through everything once. Then I closed the envelope, folded it lengthwise, and put it in the inside pocket of my jacket. I thanked Carl. I shook his hand. I drove home. The anger I had expected, the loud, immediate kind that demands an audience and a confrontation, did not arrive. What came instead was clarity. The cold, precise, entirely usable kind. I had felt it before in high-stakes situations where an emotional reaction would have been the most expensive thing I could afford. A negotiation going wrong at 2 a.m. The moment I understood a contract had been constructed to disadvantage me. Clarity like that is not pleasant. But it is far more dangerous to the person on the other side than anger ever is. The next morning, I had Diana's coffee ready at 8 o'clock. She thanked me. I said, of course. That afternoon, when Diana was showing a property and Lily was at a friend's house, I went to my home office, unlocked the gray cabinet with my own key, and looked at it carefully for the first time since Lily's question. The lock was intact. Nothing had been forced. Someone had used the right key, the copy Diana had needed in 2016 when I was in Seattle for an extended trip, and a document had to be accessed quickly. I had given it to her without considering what giving it meant in the long term. The papers inside were present and accounted for, but not quite in the positions I kept them. The trust document sat a ½ centimeter off its usual alignment. One property file had been returned at a slightly different angle, small enough that I would never have noticed before knowing what I was looking for. He had gone through all of it. The trust structure, the property holdings, the investment accounts, the complete financial portrait of everything I had built over 20 years, laid out in documents that were supposed to exist between my eyes and my attorneys alone. He had not been browsing, he had been mapping, learning the exact shape and scale of what he was dealing with before making a move. This had not been impulsive. This had been constructed deliberately and in advance. I went back to Carl's report that evening and read past the surveillance section to the professional background he had compiled on Nathan Cole. Board-certified neurologist, 44 years old. Academic publications. Conference presentations. Standard credentials, the kind that read cleanly on paper. Then, in the subspecialty field, a line I read once, and then set down and read again, cognitive assessment and capacity evaluation. I did not know yet why that phrase mattered. I wrote it on a separate piece of paper anyway, folded it, and put it in the front pocket of the legal pad I kept in my desk drawer. Then I picked up my phone and called Patricia Howe. She was a forensic accountant I had worked with during a vendor dispute in 2016, careful, thorough, and constitutionally unable to soften a finding. She answered on the second ring. I told her I had a financial situation that needed examining, that it needed to be done quietly, and that I would explain the full scope in person. She said, I've handled most kinds. I said, come in tomorrow and I'll show you. I hung up and sat in my office in the quiet of an empty house looking at 6 words on a folded piece of paper. Carl Briggs had confirmed what my instincts had been telling me for over a year. But confirmation is not a plan. It is simply the ground clearing beneath you so you can finally see what you are standing on. At that point, I still believed I was dealing with an affair. What Patricia Howe called me about 3 weeks later had nothing to do with an affair. It had to do with my money and a legal mechanism I had never once considered that anyone would try to use against me. Patricia's call came 3 weeks after our initial meeting. 4 words, I need you here. I recognized the construction she had used it in 2016 when the vendor audit had opened into something larger than either of us had been expecting. I drove to her office without asking for more than those 4 words. She did not soften findings. That was the thing I had remembered most clearly about working with her the first time she presented numbers the way a radiologist presents imaging, with the same clinical remove, and she did not adjust the interpretation based on what the patient hoped to see. I sat across from her desk, with nothing between us but the spreadsheet she had laid face up on the surface. It covered 7 months of activity beginning October of 2021. The transfers ran through Diana's Realty LLC, a legitimate operating entity with regular commissions, management fees, and contractor relationships passing through it, which was precisely the point. Each flagged amount had been structured to resemble an ordinary business expense, a vendor payment, a subcontractor settlement, a consulting disbursement, small enough individually to have attracted no attention, incremental enough collectively to have added up quietly over time. Patricia walked me through it line by line and did not abbreviate. October 2021, $38,400 logged as a contractor deposit. November, $71,200 listed as a vendor settlement. December, $94,500 categorized as a consulting fee. Each amount larger than the last, each one tied to a receiving entity that carried no verifiable relationship to Diana's actual real estate operations. What I've traced to date, she said, is $812,000 distributed across 11 separate transfers. She paused in the way she paused when she needed the next sentence to land squarely. And Arthur, I don't think this is all of it. I asked how far back the account structures would allow her to look. Mid-2021, she said, perhaps earlier with the right access. I told her, don't rush. Be thorough. She nodded once and made a note. What she would eventually find after 11 more months of careful forensic work was $3.8 million spread across 23 distinct transactions. I did not have that figure yet. I told her to take whatever time the work required. I drove home on the highway without the radio on. $800,000. Moved in amounts designed to stay below the thresholds that trigger automatic financial review. That kind of architecture does not happen by accident. Someone who understood how forensic accountants trace irregular activity had built that transfer pattern deliberately and with patience. The same someone who had, weeks before any of these transfers began, stood at my filing cabinet and mapped the precise scale of what he was working toward. That night past 11, with the house silent and Diana's footsteps long since settled into quiet, I sat down at my desk and opened my laptop. I typed Nathan Cole, neurologist, Hargrove, his professional profile loaded cleanly. Johns Hopkins Medical School, board-certified neurologist with a clinical adjunct appointment at Hargrove University Medical Center. His academic publications addressed something the papers called cognitive decline assessment protocols, the standardization of neurological evaluation for purposes that extended beyond the clinic. His name appeared across 3 separate articles. Not in medical journals, in state bar publications, legal journals written for attorneys and judges, addressing the use of neurological capacity evaluations as evidence in guardianship proceedings. I read the phrase, guardianship proceedings, and pulled up the state statute. I read the statute the way I have always read contracts from the first clause without skipping, treating every line as potentially the one that changes the meaning of everything before it. To file an emergency guardianship petition, a petitioner must demonstrate that the proposed ward represents an immediate danger to themselves or to others in their care. One qualified medical evaluation is sufficient to support the filing. The court may issue a temporary order on that basis without the notification requirements that would ordinarily give the respondent advance warning before the filing date. I read that paragraph twice. Then I set the laptop to the side. I want to try to explain what it felt like to sit in that room at 11:30 at night, reading dry legal language about the formal, procedural mechanism for removing a human being's right to govern their own existence. Not criminal prosecution, not divorce. Guardianship is civil law protective by statute. It carries no finding of wrongdoing. It requires only a finding of incapacity. If the petition succeeds, the ward's assets pass to the management of a court-appointed guardian. Their signature on documents carries no independent legal weight. Every decision they once made about their money, their medical care, their child's living arrangements now requires another party's written authorization. The transfer records, the neurologist who published in legal journals, the health questions starting in November, the suggestion to see a different doctor, the filing cabinet, photographed and studied. Each piece had been sitting in its own category, just plausibly within the range of alternative explanation. Now they had collapsed in the space of one night into a single structure. I found the piece of paper I had written on weeks earlier and kept folded in the front of my legal pad. Nathan Cole. Neurology Subspecialty Cognitive Assessment and Capacity Evaluation. The night Carl had filed it in his report, I had written it down because I did not yet have a place for it. I had known enough to keep it. Now I had a place for it. It wasn't a credential. It was a role description. Diana was not planning to leave me. She was planning to erase me legally to place documents before a judge that would transfer every decision I made about my own life, my assets, and my daughter to someone else's court-sanctioned authority. She had found the right specialist to construct the evidentiary foundation for that outcome, a man whose entire professional reach was building the medical record that makes such an outcome legally achievable. I picked up my phone and called one person. Not the police, that was not where this led yet. Not Maggie, not Dr. Ellis, my attorney. Because what I needed was not help in the ordinary sense. What I needed was a strategy one built with enough precision to dismantle something that had been under construction for well over a year, and to do it without tipping a single person off that I had finally understood what I was looking at. $800,000. A neurologist who publishes papers for judges, not for patients. A filing cabinet that had been studied from the inside by someone who was never supposed to be there. Arthur is about to sit across from his attorney and see for the very first time the full shape of what is being built against him. Before I continue, drop the number 8 in the comments right now. Just that. It tells me you're still here, and it tells me this story is worth finishing for you. A note. The story ahead contains some fictional elements written for entertainment and educational purposes. If that's not what you're here for, it's completely fine to step away, no hard feelings. Frank Harmon had been practicing law for 31 years. He was not a dramatic man. He didn't raise his voice, didn't pace the room, didn't deliver speeches about strategy. He was the kind of attorney who read a document, once placed it face down on the desk, and looked at you afterward with complete, unhurried stillness. In 30 years of working with him, I had learned that the stillness meant he had already understood something important and was deciding what to do with it. I sat across from him that July morning and laid out everything without editing any of it. Not in the order I might have chosen to make myself sound better, all of it. Beginning with Lily's question 5 months earlier and ending with what Patricia had found in the accounts. The affair documented. The neurologist whose published work appeared in legal journals about guardianship proceedings. The filing cabinet opened and studied. $800,000 in transfers structured to avoid detection. And a piece of paper with 6 words on it that I had not fully understood until I read a state statute at 11 o'clock at night. Frank listened without interrupting once. When I finished, he picked up a pen and drew 3 boxes on his legal pad connected top to bottom by arrows. "Let me show you what you've described," he said. First tier, a fabricated Alzheimer's diagnosis. Legitimate credentials, real medical formatting. A patient file that would pass professional verification, because the person who built it knew exactly what the right documents looked like. Second tier, staged behavioral evidence and a constructed medical history to support that diagnosis. Observed decline documented over months. Health questions asked and recorded. A suggestion to see a different physician because the one I'd had for 20 years would not be producing the required findings. Third tier, an emergency guardianship petition, filed simultaneously with a custody motion and an asset freeze. Structured as an emergency specifically because emergency proceedings give the respondent less time to prepare. Frank set the pen down. This is what a well-executed guardianship fraud looks like, Arthur. And Dr. Cole clearly knows exactly what it looks like, because he has studied it professionally from the inside. Then we stop them now, I said. He shook his head once. If you react now, confront Diana, freeze the accounts, do anything visible, Nathan adjusts his records. Diana claims she acted out of genuine fear. You get a contested divorce likely resolved in your favor, and they walk. No perjury, no criminal exposure, nothing irreversible. He tapped the legal pad. But if you wait and let them commit fully to a legal filing, everything changes. Perjury submitted to a court is not an error that can be revisited. The evidence they fabricate becomes the evidence against them. What about the money? I asked. Patricia says it's already past $800,000. Which is exactly why you don't touch it yet, Frank said. If you freeze the accounts today, they pivot. Diana reclassifies the transfers as authorized distributions. Nathan adjusts his timeline. You have a civil dispute and nothing criminal. But if you let Patricia document every transaction from this point forward, every dollar has a paper trail with a date, a destination, and a structure that tells a story. In a fraud case, that money is not your loss, it is your evidence. The court can order full restitution. He looked at me directly. You are not losing that money, Arthur. You are documenting it. Then he said something that I did not fully understand the significance of until several months later, when it mattered more than anything else in a courtroom. You need to understand how they'll likely file. If they structure this as an emergency ex parte petition, claiming you represent an immediate danger to yourself or to Lily, the court rules change significantly. Discovery requirements are relaxed. They'll assume that limits our ability to respond. He leaned forward slightly. Here is what they won't have considered under emergency rebuttal provisions. A respondent at the subsequent show cause hearing may present counter-evidence that was gathered and fully authenticated before the petition's filing date without the standard pre-trial discovery process. If your evidence is real, complete, and authenticated before they file, we can present everything at the hearing. On the spot. Legally. Their emergency structure becomes ours. I told him I wanted to install a recording system in the house. He wrote something on the pad before looking up. State law recognizes single-party consent for audio recording within one's own primary residence. The critical phrase is party to the conversation. He underlined it. You must be present in or party to the communication being recorded. We'll need to account for that carefully when we structure how the recordings are framed. But it's workable. Plan for it. He gave me a list of what he needed. 2 independent cognitive evaluations from 2 separate institutions with no connection to Nathan Cole, scheduled as soon as I could arrange them. Pacemaker data pulled from Dr. Ellis, an implanted cardiac device with an accelerometer log, would give us a physiological record of my physical activity time-stamped to the minute. Patricia's financial documentation ongoing and thorough. And then, watch for a power of attorney. They'll need one durable, meaning it takes effect the moment you sign without waiting for any declaration of incapacity. When they present it, don't refuse it. Don't hesitate. Don't show any sign that you understand what it represents. We will address it when it comes in a way they will not expect. He looked at me across the desk before saying the final thing. Arthur, your single greatest advantage in this situation is that they believe you are exactly what you appear to be. An older man, retired, perhaps beginning to slow, someone who would not see this coming. He paused. Are you willing to keep appearing that way for however long this takes? I thought about 20 years of early mornings of deals held together through patience of problems that had no solution except to outlast the people who believed they had already won. I've been patient my entire career, I said. I can wait a little longer. I walked out of Frank's office into the July heat and stood on the sidewalk for a moment. There was one thing I hadn't mentioned to him, a complication that made everything slightly more urgent. Someone inside my own house had been watching me, and I had only just begun to understand how deep that arrangement went. Evelyn Marsh had worked for me for 22 years. She had been with the company when it was 20 people in a converted warehouse on the west side of Hargrove, and she had still been there on the morning I signed the papers to sell it. She knew my schedule better than I did my coffee order, which of my former business contacts still returned calls, which medical appointments I considered private. I had trusted her with more than I trusted most people, which made what I discovered in late July both devastating and, once I recovered from the initial shock, unusually useful. The realization came in increments. I had told only Evelyn about my follow-up with Dr. Ellis in late June. It wasn't in any shared calendar. I hadn't mentioned it at dinner, hadn't said a word to Diana. And yet that week, Diana had asked whether the appointment had gone well. She asked it in the tone of someone who was monitoring, not someone who had heard something in passing. A few weeks later, the same pattern appeared around the morning I had driven to Patricia Howe's office. I had told Evelyn I had a meeting with a former business contact. Diana asked that evening whether I had a good time connecting. Light in delivery, specific in knowledge. I set a test in the third week of July. I told Evelyn on a Tuesday morning that I would be flying to Charlotte on Wednesday to meet with an old partner, gave her a departure time, a return time, a list of files to have ready when I got back. Then I called no one else and did not book any flight. Wednesday morning, I drove out of the neighborhood. At the time I would normally leave for the airport, went 3 blocks, turned around, and parked at the far end of a street that gave me a clear sight line to the front of my house. I turned the engine off and waited. At 10:17, Nathan Cole's gray sedan came around the corner and pulled into my driveway. Not the street, the driveway. He was inside for 2 hours and 10 minutes. Then the car backed out and drove away. I drove home 20 minutes later, made lunch, and read on the back porch for an hour. When Evelyn arrived that afternoon to drop off the files I had requested, I looked at her directly and smiled. She smiled back. Neither of us said anything beyond what was necessary. I called Frank that evening. Evelyn is compromised. Someone has been passing scheduling information to Diana for months, appointments, meeting locations, things that Evelyn would have known and no one else. Frank said, let her go. I said no, I have a better use for her. I found out later how Diana had gotten to her. Evelyn's daughter had been diagnosed with a rare autoimmune condition in 2020, and the treatment was indefinite. The bills had been running for 2 years. Diana had quietly helped cover 2 of those payments beginning in early 2022, asking nothing openly in return. By the time I discovered the arrangement, Evelyn had been reporting to Diana for 8 months. She had likely convinced herself it was care, that a worried wife had legitimate reasons to stay informed about her husband's health and schedule. People rarely betray someone for purely financial reasons. They need a story that makes the decision feel like the right one. Diana had been deliberate enough to provide her one. This did not change what I had to do with it. It only changed how I felt doing it. What I had to do with it was turn it into a channel. Starting in August, I began leaving post-it reminders in visible locations around the house, places Evelyn moved through routinely. Lily pickup 3 o'clock. Dr. Ellis Tuesday. Keys don't leave without. The notes themselves were unremarkable. What they represented to a neurologist who built behavioral documentation for legal proceedings was clinically significant. A person using external written reminders for tasks they previously managed without them is exhibiting what clinicians call early compensatory behavior, one of the first observable markers of someone whose memory is beginning to require structural support. Nathan Cole would recognize that pattern immediately. He would log it. I placed the notes where Evelyn would notice them, she reported. Diana and Nathan added it to the record they were constructing. From my side, it was the most efficient piece of misdirection I ran. During that period, it cost me nothing and gave them exactly what they needed to keep believing. But the misdirection had a cost I had underestimated. Every piece of real preparation, the cognitive evaluations I was arranging, the financial documentation Patricia was building, the recording system I was beginning to plan, had to happen in windows where Evelyn was absent and could not observe the contradiction. Each appointment, each meeting, each piece of documentation had to be invisible to the channel I was deliberately feeding. I was running two operations with opposite requirements. The defensive one demanded visible decline, scattered reminders, apparent forgetfulness, the small theater of a man who needs notes for his own front door. The offensive one demanded precision, careful, authenticated evidence gathered without a trace. Evelyn was the point where those two operations could come apart. One inadvertent observation, a document she shouldn't have seen, a phone call she caught a fragment of, and the entire defensive layer would need to be rebuilt. I had told Frank I had a better use for her than termination. I had been correct, but I had not fully calculated how careful that use would require me to be. Nathan Cole was preparing to walk into a courtroom and tell a judge that my mind was failing. The only way to dismantle a fabricated medical case is with a real one independently verified, comprehensively documented and dated before any of his claims existed. That meant I needed a hospital, a neuropsychologist I had never met, and an appointment that no one in my house would know about until it was already done. On the morning of September 8th, I drove myself to Hargrove University Medical Center alone. Having scheduled the appointment 3 weeks earlier through a patient portal I had created specifically for this purpose, using a personal email address I had opened through a separate provider and never shared with Diana or anyone else in my household. I parked in the east garage, found the elevator, and told the receptionist at the Department of Neuropsychology that I had a 9 o'clock appointment for a full cognitive evaluation. She looked at me the way receptionists look at older men who arrive at neuropsychology departments unaccompanied, the careful, slightly concerned assessment of someone deciding whether everything is in order. I gave her my most reassuring smile and took a seat. Dr. Patricia Osei was 40 years old and wore the expression of someone who had made peace long ago with being skeptical first and reassured later. She reviewed my intake information, noted that I had self-referred without a physician's recommendation, and looked up from the form. Most patients in this department come through a referral pathway, she said. Primary care neurology, sometimes a family member. I understand that. My situation falls slightly outside the standard pathway. I leaned forward. Someone is going to file a legal document in the next few months, asserting that I have significant cognitive decline. I need an independent evaluation conducted and dated before that document exists. She set her pen down. That is an unusual reason to request a neuropsychological battery, Mr. Weston. I assure you it's a necessary one. She held my gaze for a moment. That was longer than a polite pause. Then she opened the file. What followed was 4 hours of the most systematic examination of my cognitive function I had ever undergone. The MMSE, the Mini Mental State Examination, a full-spectrum screen covering orientation, registration, attention recall, and language 30 out of 30. The MOCA, the Montreal Cognitive Assessment, 28 out of 30, a score doctor. Osei did not flag with any concern. The Hopkins Verbal Learning Test, which evaluates how the brain encodes and retrieves new verbal information across multiple learning trials, 94th percentile for men in my age group. The Trail-Making Test, which measures processing speed and the brain's capacity to shift fluidly between competing cognitive demands. 92nd percentile. She ran supplementary assessments for abstract reasoning, spatial processing, and working memory. 4 hours of structured examination from 4 independent instruments, approaching the question from different angles, producing the same answer from each one. When it was complete, Dr. Osi set her materials down and looked at me with the measured neutrality of a clinician who has encountered an unexpected finding and has no intention of overstating it. Mr. Weston, you score in the 94th percentile for executive function for men your age. That figure does not require any qualification. A pause. Whatever you are preparing to defend yourself against, you are medically prepared to do so. I received a 37-page evaluation report signed by Dr. Osei and stamped with the Department of Neuropsychology's official institutional seal. The date of assessment appeared in 3 places: the cover page, the summary, and the examiner's certification. I walked to my car in the east garage, started the engine, and stayed in the parking structure for 15 minutes without moving. I am not a man who routinely stops to sit with something. The professional life I had built ran on forward motion, but sitting there on a September morning with 37 pages in the seat beside me, I let myself register one thing clearly: this part was real. Whatever else was happening, the fabricated appointments, the 10 months of financial transfers, the man who had stood at my filing cabinet and mapped everything I owned, this part was true. My mind was intact. The test said so. Then I started the car and drove to lunch. 2 weeks later, on the morning of September 22nd, I walked into Hargrove General Hospital's Department of Psychiatry and sat down across from Dr. Marcus Webb. He was a compact man with the attentive manner of someone who had spent a long career listening to accounts that did not always immediately add up. I used the same approach: direct, complete, nothing omitted. I explained the guardianship fraud being constructed, the fabricated medical documentation, and the need for a second independent evaluation from a clinician at a different institution with no connection to the first. Dr. Webb asked 3 clarifying questions. Then he began a comprehensive psychiatric evaluation that covered structured clinical interviewing, cognitive screening, within the psychiatric assessment framework, mood and thought organization, and behavioral assessment across multiple clinical dimensions. His written findings stated no indicators of any cognitive disorder, neurodegenerative process, or psychiatric condition affecting decision-making capacity. Both reports, September 8th. Hargrove University Medical Center Department of Neuropsychology. September 22nd, Hargrove General Hospital. Department of Psychiatry were delivered to Frank Harmon the following week. He placed them in the office safe with a signed chain of custody log and a date of receipt. 2 independent evaluations. 2 separate institutions. 1 month apart. Both dated September 2022. Nathan Cole filed his Alzheimer's assessment in November of 2022. It documented clinical observations and cognitive deterioration beginning in August of 2022. August, 1 month before my first evaluation. Here is why that sequence matters more than anything else in the assessment itself. Nathan Cole was going to tell a judge that I had been cognitively impaired since at least August of 2022, to make the case appear more serious and more established. He had positioned the deterioration as far back as possible months before the filing. What he did not know was that 2 independent evaluations from September showed the 94th percentile. He had claimed deterioration from a month before real evidence existed that directly contradicted it. In reaching for credibility through an early onset date, he had stepped into a chronological position he could not defend. In law, sequence is everything. The dates matter more than the content. September comes before November. Real evaluations precede fabricated claims. A medical record asserting deterioration from August cannot stand against 2 independent September evaluations that say otherwise from institutions with no motive to coordinate. Conducted by clinicians who had never heard his name. Science cannot be backdated. There was one more thing I needed to build. Something that required precision, complete invisibility, and the understanding that Diana at some point would present me with a document I should never sign. And something had been sitting quietly inside my house for nearly 20 years. Installed behind the walls of a home Diana had renovated and redecorated twice that she had walked past 1,000 times without ever having occasion to ask what it was. Here is something I learned in 20 years of building software security is not about what people can see. It is about what they don't know is there. In 2003, when the company was scaling faster than our data infrastructure could safely support, I built a local network-attached storage system at home, a NAS unit running on physical Ethernet cable threaded through the interior walls of the house. Not wireless, no internet routing, no remote access point of any kind. A fully isolated local area network air-gapped by design, built to hold sensitive client contract files outside the reach of any network breach that might compromise the company's servers. The enclosure itself was compact. A white box slightly larger than a hardcover book installed inside the utility closet at the back of the storage room behind the water heater. No external markings, no visible LED indicators from the doorway. A faint hum that required standing directly beside it to detect. A single shielded Ethernet cable ran from the enclosure through the interior wall to a concealed port at the back panel of my home office desk, one physical connection, entirely invisible unless someone removed the desk from the wall and looked. In 2009, following a physical breach at the company's previous office, someone had entered after hours and copied files from a workstation left accessible. I expanded the system. I added audio and camera inputs, microphones embedded in the smoke detector housings in the living room and hallway, with audio capture sufficient for clear voice recording at conversational distance. A camera fitted into the face of an antique clock I had purchased for that specific purpose positioned in the hall. A second camera in a recessed ventilation panel in the home office. All inputs fed to the NAS drive on the isolated local network. The recording was motion-activated continuous monitoring writing to storage only when movement was detected in frame clearing on a 21-day rolling cycle. In September of 2022, I replaced the storage drives to extend the archive capacity. Diana had renovated the house in 2018, new flooring, new paint, new fixtures throughout. No one had opened the utility closet or looked behind the water heater. She had checked our household Wi-Fi network twice. I found the query timestamps in the router's access log. Both times she returned two connected devices, my laptop and her phone. The wired NAS sat on its own isolated physical network, completely invisible to any wireless scan. She had walked past the utility closet door several thousand times in 10 years. I had simply never given her a reason to open it. Frank had reviewed the applicable legal framework. Operating a home security system in the common areas of one's own primary residence, installed years before the marriage and before any dispute existed, did not require the consent of other household members in the way that a targeted listening device would. And more importantly, Frank had been explicit: the recordings were not going to serve as our primary evidence. They would serve a specific secondary function, which I will explain when we get to it. In September, I also ordered a forensic ultraviolet pen through a private account, the kind used in professional document authentication work, and began practicing a specific technique, a standard visible signature written in the normal fashion with the right hand, and simultaneously in the same continuous motion of the hand, a secondary notation in UV ink along the margin of the page invisible under standard office lighting, readable only under a specific ultraviolet wavelength. Two separate records produced in a single unbroken hand movement, the second one entirely undetectable to any observer watching the first. It took 3 weeks of evening practice on locked scratch paper before the motion was natural enough that it would not register as anything unusual to someone watching. On a Thursday afternoon in late September, at around 4 in the afternoon, I was at my desk with two things in front of me. The NAS live feed open on my tablet. I was testing camera angles in an empty living room, verifying audio sensitivity levels, and a page of scratch paper with UV practice repetitions across it. Evelyn knocked and came through the door without waiting. She had worked for me in that capacity for 18 months since the company sale. In all of that time, she had knocked and waited. She had followed that protocol consistently without exception, because I had established it. From the first week, the office was a working space, and I needed to be interruptible on my own terms. I did not have time to consider why she had broken from it now. I had 1 second. I closed the NAS feed tab on the tablet. I turned the scratch paper over onto its blank side with one motion. I set the tablet screen down beside the desk lamp. When she was fully inside the doorway, I was leaning back in my chair, pen in hand, looking at the middle distance with the mild, unfocused expression of someone interrupted from no particular thought. She placed a folder on the corner of the desk documents I had requested, a renewal summary, a scheduling note. She spoke through the contents efficiently. I listened and responded at the appropriate intervals until I noticed that she had stopped. Her gaze had come to rest on the pen in my right hand. A silver barrel medical-grade grip, texture a tip slightly broader than a standard pen. Not the kind of thing that lives in a desk drawer. Like new pen, she said. I raised my right hand and looked at it with the mild, practiced tedium of a man for whom this was a minor inconvenience he had come to accept. Doctor's suggestion. The grip in the mornings has been a little inconsistent lately. He wants me monitoring the pressure control while I'm writing. I set it down with the careful deliberateness of someone managing the thing exactly as directed, then moved my attention back to the papers in front of me. Evelyn nodded. Before she turned toward the door, her eyes moved briefly a half-second to the tablet lying screened down on the desk beside the lamp. The natural, involuntary gaze of someone registering an anomaly at the edge of their attention. Not suspicious, just present. Then she left. I sat without moving for 30 seconds after the door closed. My heart was beating faster than I wanted to admit. Not because I had failed to manage the situation, I had managed it, but because I understood with the particular clarity that only a close call produces exactly how thin the margin had been. Another 3 seconds in the doorway, a slightly different angle of approach, and she would have seen something she would not have been able to unsee. I sat with that for a moment, and then I understood what she would report. Arthur was working with a medically prescribed pen because his morning grip was unreliable. His doctor had recommended it. He mentioned it with the mild, familiar resignation of someone who has had the same minor frustration for long enough to stop being surprised by it. One more observation for a file being built, to document a man declining quietly from the inside. I had tripped into the most believable piece of misdirection in the entire operation. One unplanned one improvised sentence, and I had handed them something more credible than anything I could have constructed deliberately. The best cover story is not the one you rehearse. It is the one that arrives in the space between your heartbeats when you have no other option. By October, 2 things existed in my house whose full purpose no one else understood. A forensic pen in the inside pocket of my jacket, and a recording system running silently behind the water heater that had been observing the living room for 3 weeks. What it would capture next, I could not know. I could only confirm it was running, storing, and set to the right sensitivity threshold. What happened the following month? The events Diana would later describe to a judge in tears and with precisely rehearsed detail as the night everything changed. I will tell you now, she was not wrong to call it that. She simply had the wrong account of what was actually happening upstairs, while she was downstairs believing she was alone in the house. I want to be careful with how I tell this part, because what happened on that October night matters precisely because of what did not happen and because the device, running inside my chest, was recording evidence with the complete indifference of hardware that simply tracks the truth. Dinner that evening was unremarkable. No particular tension, no unusual conversation. Lily had questions about a science project that occupied most of the table. Diana was attentive to her and distracted during the stretches in between. I went upstairs at 9:15. I took my medications the way I had taken them every night for 2 years. A blood pressure tablet, a cardiac support prescription, and a low-dose sleep aid that Dr. Ellis had prescribed in 2021 when my sleep architecture began breaking down in the first months of retirement. The sleep medication had a pharmacy dispensing record with a timestamp for every refill. I had been taking it consistently on the same schedule for 22 months. The pacemaker in my chest is a Medtronic Azure XT implanted in March of 2020. Following a brief arrhythmia episode my cardiologist considered manageable but wanted monitored. Most people understand that a pacemaker regulates cardiac rhythm. What most people do not know, what does not appear in standard patient materials, is that a contemporary device in this category contains an integrated triaxial accelerometer sensor. It tracks two things simultaneously: heart rate and physical movement, both time-stamped to the second, both synchronized to the manufacturer's secure server. Dr. Ellis received a certified monthly summary. I had full access to every log file since implantation. The data from that night, which Dr. Ellis would later extract and certify in a formal report, is precise. 9:47 p.m. heart rate 57 beats per minute. Accelerometer low activity, consistent with horizontal rest. 10:23 p.m. heart rate 54 beats per minute. Accelerometer near zero. Consistent with deep sleep in combination with a prescribed sleep aid. 3 a.m. heart rate 58 beats per minute. Accelerometer near zero. Consistent with REM phase. 6:10 a.m. heart rate 62 beats per minute. Accelerometer movement initiating. Consistent with waking. Over 8 hours and 23 minutes. The accelerometer recorded 0 movement spikes above the stillness threshold. 8 hours and 23 continuous minutes of complete physical immobility logged time-stamped and stored on a server I had no access or ability to modify. I came downstairs at 6:15. Diana was standing at the stove with her back to me, wearing a long-sleeved navy shirt she had not been wearing the night before. When she turned to set a cup on the counter, I saw it a bruise on her left upper arm several inches across. New. The coloring of something that had occurred in the previous 12 hours. She was moving that arm with a deliberateness that differed slightly from her ordinary range. She looked at me. I looked at her. "Good morning." "Good morning." She turned back to the stove. I made toast. I read for 20 minutes. Then I put on my jacket and went for my morning walk along the same route at the same pace as I had done for months. From the bench at the far end of Riverside Park, where I had been making calls I didn't want made from inside the house, I dialed Frank. She made her first move. "Last night, I was upstairs asleep. I have 8 hours and 23 minutes of pacemaker accelerometer data showing 0 physical movement. Dr. Ellis can extract and certify the full log. The pharmacy has time-stamped dispensing records for the sleep medication." Frank was quiet for exactly 1 second. "Good. Say nothing at home. Let Carl continue." Carl called that afternoon. Diana had gone to an urgent care clinic on the east side of downtown at 10:45 in the morning. She had reported to the intake nurse that she had stumbled and fallen against the edge of a kitchen cabinet. The nurse had documented the visit, photographed the injury, and recorded the presented cause in the clinic system. The report existed in a medical record that had no connection to Nathan Cole, to Hargrove University Medical Center, or to anyone involved in the case. When I relayed this to Frank that evening, he took the deliberate pause of someone placing things in order. "The clinic record gives her a credible independent medical file," he said. and the accelerometer log strips every second from any timeline she intends to assert. She doesn't know the device tracks movement almost no patient does. It isn't disclosed in standard documentation. She built a story around a gap she assumed existed. A sensor she didn't know about closed it. Diana moved her left arm carefully through dinner that night. She did not mention it. I did not ask. My pacemaker had been running inside my chest, through all of it, doing what it was built to do, recording every rhythm, logging every absence of motion with the indifference of a device that does not take sides. Diana had staged an assault. The cardiac implant in my own body had recorded the alibi. She had constructed her case around what she believed a sleeping man could not prove. She had not known what that sleeping man was carrying. That same evening, after Lily had gone up to bed and the house had gone quiet, I went to my office and sat down at the desk. I had been putting this off for 3 weeks, the moment I would actually look at what the NAS had recorded since I replaced the drives in September. I opened a file time-stamped 2 nights before the bruise appeared. I pressed play. What I found there kept me sitting very still for a very long time. Not because of what Diana said, because of what she said in the moments just before she agreed. Arthur has the NAS recording. He has been sitting in a locked room for 3 weeks, knowing it exists, and not yet looking at it. Tonight he opens the file. What he hears in that recording is the moment everything in this story becomes irreversible for Diana, for Nathan, and for Arthur himself. Before I reveal what that recording captured, comment the word "ready" if you're still with me. Because what comes next, you won't see coming. A note. This story contains some fictional elements added for entertainment and educational purposes. Names, places, and settings are coincidental, but the truth at the heart of it is something I believe is worth your time. I locked the office door from the inside. The server enclosure hummed in the usual way, the same sound I had heard 10,000 times over 20 years, and never once registered above the threshold of background noise. I opened the NAS interface on my laptop, found the motion-activated file time-stamped 5 evenings before Diana's bruise appeared, and pressed play. Before I tell you what was in it, I should tell you about the night it was recorded. I had been out walking and came home earlier than planned, because the weather turned and rain arrived fast without the usual warning from the sky. I was coming up the front walk when I heard voices through the living room window. 2 of them. I stopped at the side gate before I reached the front door. I stood there in the rain for approximately 4 minutes. In that time, I heard most of what I am about to describe, imperfectly filtered through rain and glass, but clearly enough to understand the substance of what was being said. I opened the front door. Diana said they were reviewing some investment materials. I said of course and went upstairs. Later that night, I pulled the file from the NAS archive. The microphone in the smoke detector had captured the same conversation with considerably better clarity than I had managed from outside a wet window. Frank had been specific about how we would handle this. The recording served as corroborating documentation of a conversation I had personally partially witnessed from the property. In the chain of evidence, that distinction would matter. What I had heard from the garden gate was confirmed in full. Nathan Cole's voice on the recording had a quality I could now place precisely rehearsed. Not performed for an audience, performed for efficiency. This was a man who had thought through every component of a plan until the urgency of it had become unnecessary, and who was now delivering the components the way a project manager delivers a timeline. Methodical. Complete. Without pausing to check whether Diana was absorbing it, because he had long since moved past the possibility that she wouldn't. He went through each element in sequence, the neurological assessment filed in November, the behavioral documentation that had been assembled over the preceding months, the power of attorney, and when it would be presented, the structure of the emergency petition, and why that structure was preferable to a standard filing. He spoke about my cognitive file with the clinical remove of someone discussing a patient he had never met. And then Diana said something Sometimes I think maybe we should just file for divorce, without all of this. A pause. He's not a bad person, Nathan. He isn't. I stopped the recording. I sat with those words for longer than I had planned to. I had spent 2 years observing what Diana had become, cataloging every lie by its category, every manipulation by its purpose. I had built a file on the woman across the breakfast table, in the same way I had once built files on business adversaries with the same cold methodology. And in 6 words on a recording in a locked room, she had reminded me of something I had been deliberately not thinking about, that there had been a person there before Nathan, who had sat with my 83-year-old mother for 6 hours in a hospital waiting room because no one asked her to. The Diana in that recording still knew that about herself. She was using it as an argument. And Nathan answered it the way Nathan answered everything with arithmetic. I pressed play. A divorce proceeding with the prenuptial agreement, he said in the same register he had used to describe the filing timeline, will run a minimum of 6 years before resolution. After attorney fees, after litigation, you would walk away with a settlement in the range of $3 to $4 million. Is that the life you've been describing to me? A pause of perhaps 2 seconds. You're 38 years old, Diana. This window does not stay open. Silence from her. What I am providing is legal authority over an estate of $47 million. Not a settlement, the estate itself. Managed at your direction without Arthur's signature on anything. The difference between those 2 outcomes is not a matter of degree. Another silence. Longer, the kind of silence that carries weight in both directions. Okay, she said. You're certain. Okay, we do it your way. He moved immediately to the injury. He described it clinically in the same instructional tone he had used for the legal filing structure as a procedure, with a rationale and a single point of execution. One documented incident consistent with the behavioral pattern already on file captured independently through the clinic system. Diana asked, "Does the first part really have to happen? Is it necessary?" "Once," Nathan said. "After that, it is paperwork and patience." She did not respond to that. A moment later, they were discussing the November scheduling and the timeline for presenting the power of attorney. I closed the file. I had spent 2 years trying to understand what had happened to the woman who read to Lily every night, without exception, in the specific and irretrievable way of someone who never missed a single night across 4 years. Nathan Cole had answered part of that question for me. He had found her at exactly the right moment the retirement had shifted the household structure in ways she had not anticipated and had not been able to name. And he had given her a specific number against a specific deadline and a plan that converted her unhappiness into something that had a procedural shape. He was skilled at this. 2 other families, which I would learn of later, had found that out before we did. I copied the recording to a separately purchased encrypted external drive. I printed a notation page on the home printer, signed it in standard ink, dated it, and added a single clarifying line. Extracted from Home Residential Security, NAS installed 2003, operated continuously. Corroborates direct observation by homeowner on listed date. October 2022, of conversation between property owner and external parties in common area. The following morning, I drove the drive to Frank's office. He logged the receipt, documented the chain of custody, and placed it in the safe beside the medical evaluations. Diana was not the architect. She had been a person with real grievances and a specific financial ceiling, found at the right point by someone who had built a professional process for converting those circumstances into a plan. Nathan Cole had provided the credentials, constructed the legal framework, absorbed the moral weight of the decision, and moved her step by step into something she could not walk back from without destroying herself. Understanding that did not change anything about what I needed to do. It changed everything about how it felt to be doing it. When I finally stood up from the desk, I had an encrypted copy of everything the NAS had captured, and the kind of clarity that comes only when you stop hoping the answer will turn out to be different from what it already is. What I did with that clarity over the following weeks would determine everything, beginning with the morning I walked out of that house for the final time. Diana's filing arrived at Frank's office on the morning of December 9th, 2022. He called me within the hour. She filed, he said. Emergency temporary guardianship petition divorce and sole physical custody of Lily. A pause of approximately 1 second, which was Frank's version of a long pause. And Arthur, she filed a concurrent emergency protective order. Domestic violence basis citing the October incident documented at the urgent care clinic. The judge approved a 72-hour TRO at noon today. I sat down. The full TRO hearing is scheduled for the 20th. We will contest it. You will prevail on the TRO. The pacemaker data alone closes the timeline on the October claim, and I will have that entered into the record before the hearing date. He paused again. But the immediate order requires you to vacate the primary residence. The legal deadline under the TRO terms is January 4th. I asked him what the alternative was. There is no alternative, he said. There is only how we do this. Voluntary compliance with the order cooperating with the TRO terms in a way that is visible to the court is considerably better for your record than a constable delivering a notice. And it starts the clock on supervised visitation, which I am filing for today. We want that in the case file before any temporary guardianship ruling is issued. He sent me the full petition that afternoon. I read Nathan Cole's assessment in Frank's conference room, 23 pages, formatted with the institutional precision of someone who understood exactly what rigorous medical documentation was supposed to look like. 12 fabricated appointments, distributed between August and November of 2022. Each entry contained real clinical language, real diagnostic terminology, genuine medical concepts applied to a patient profile that had been constructed from the outside in. The letterhead was from a legitimate hospital affiliation. The assessment codes were valid. The referencing methodology matched published professional standards. He had invented 12 clinical sessions with a man he had met socially, at most twice in 4 years. And he had built them to withstand professional scrutiny because he had known from the beginning that professional scrutiny was exactly what they would face. Diana's attorney contacted Nathan's office to verify the records. Frank told me that evening. The receptionist confirmed there was a patient file for you in their system. Which there is, he created it. What she couldn't verify without a subpoena to the internal scheduling infrastructure is whether the appointments that file purports to document ever actually took place. Sandra Price is a capable attorney. She did what any capable attorney would do. She was deceived at the level of professional verification. He filed the supervised visitation motion before the close of business that same day. The court approved it within the week, bi-weekly visits supervised at the Hargrove Community Center, with a court-appointed monitor present. Supervised. I sat with that word for a few minutes. The legal arrangement governing a man's ability to spend time with his own daughter. Diana was not home on January 4th. She had told me the previous Sunday that she had a client meeting in another city that week. A piece of scheduling that I recognized as an act of deliberate avoidance. She had chosen not to be present for the leaving. I didn't know whether that was cruelty or something else, and I had stopped having the energy to distinguish between the two. I went through the house in the way you go through a house when you are trying to fix it in detail, because you don't know the next time you will be in it, or how much of it will still be yours when you return. The kitchen Lily's spot at the end of the counter where she spread her homework, while I cooked on evenings in 2020 and 2021 before everything shifted. The dishes in the cabinet that we had picked out together from a store in the city on a Saturday, an ordinary Saturday, that I had not known I would need to remember. The hallway photographs from 2014 to 2022 aligned at the same height in frames Diana had chosen. Lily at 6 weeks, Lily at 1 year, Lily at 3, at 5, at 7. The four of us at the coast in 2019, the summer before the company sale, the last summer that looked the way I had imagined summers would look for the rest of our lives. Lily's bedroom door. I put my hand on it. I did not open it. I went to the office. I completed a final backup of the NAS archive to a second encrypted drive. I put the UV pen in the inside pocket of my jacket. I took one last look at the cabinet behind the desk. The white enclosure. The faint hum, the thing nobody had thought to ask about for 20 years. And I left it running. Then I closed the office door. I loaded 2 bags into the car. I drove down the driveway. I did not look back at the house. The first supervised visit was the following Wednesday. Lily came down the hall of the Hargrove Community Center at something between a fast walk and a run. Her backpack strap slipping off one shoulder, not looking at the supervisor or the room or anything except me. I picked her up. She was lighter than I remembered, or possibly I was simply paying closer attention than I usually had, and she pressed her face into my shoulder for a moment before pulling back to tell me about a book her class was reading. The supervisor sat at a table in the corner with a notepad and a pen and recorded whatever supervisors record in those situations. Lily did not understand why a stranger was taking notes while we ate lunch. She was not old enough to frame the question precisely, and I was grateful for that. She ate a turkey sandwich and told me about the book chapter by chapter in more detail than was strictly necessary, and I listened to every word as though it were a document I needed to memorize. I drove away from the community center thinking, and I said it out loud in the car where no one could hear me, this is not the failure. This is the beginning of the end of their plan. By January, I was gone from the house. But Diana and Nathan were still moving. 6 months later, they would make what they believed was their final and decisive step, the action that would lock everything into position permanently. They needed one more thing from me. One document, one signature. Something they believed I would hand them without understanding what I was actually giving away. The December 20th hearing resolved in our favor within the week. The pacemaker log stripped every credible second from Diana's October timeline, and the order was vacated. The TRO was gone. What remained was the larger case, and Diana and Nathan were still moving toward it. 6 months after I moved out, Sandra Price's office contacted Frank with an unusual request, an informal mediation session, just Diana and me, no attorneys present in the room. A kitchen table conversation, Sandra called it. An opportunity to resolve things like reasonable adults. Frank told me not to go. He said it 4 times over 2 phone calls, each time with a distinct additional reason: the absence of counsel created liability exposure I couldn't predict. The informal setting had no evidentiary protections for anything said or signed. The phrase, kitchen table, was a deliberate framing designed to lower the register of what I understood myself to be walking into, and the request itself suggested that something in their petition timeline had created an urgent need for a document they could not obtain through formal channels without triggering the kind of opposing scrutiny they wanted to avoid. I thanked him for each reason. Then I told him I was going. The morning of, I tested the UV pen in the bathroom of my rental apartment, a short line of notation on a piece of scratch paper. Then a UV flashlight held over the surface. Clear, fully legible, invisible in any ordinary light. I burned the scratch paper in the sink, ran water over the remains, and dressed. I put on my navy vest, the one with the left breast pocket, and placed the pen inside it, along with an ordinary pen, silver-barreled, for the table. The conference room occupied a suite in a neutral office building downtown, not Sandra's firm, not anywhere that carried anyone's name on the door. Round table, 4 chairs. Fluorescent overhead lighting of the kind that flattens everything. Diana was already seated when I arrived. She had dressed carefully, a simple charcoal blazer, no jewelry, nothing that read as effort. The presentation of a woman who had thought about how to appear reasonable in a room where reasonableness would matter. Two witnesses sat to her left, Sandra's legal assistant and what appeared to be an associate from the firm. The folder in front of them was closed. I shook each hand in turn, set my jacket over the back of my chair and sat. Diana asked how I was doing with a lightness that was genuinely well practiced. I thanked her. She asked whether I had found parking easily. I said yes. The legal assistant uncapped her pen. I wanted to make sure there was a structure in place. Diana said in the measured tone she had used for difficult conversations, our entire marriage not unkind, not pressured, calibrated. Something that protects you, Arthur. In situations where decisions need to be made quickly, and you might not be in the best position to make them independently, this would allow me to act on your behalf. She slid the folder across the table. The document was a durable power of attorney. I want to be precise about the word durable. It is the word that changes the meaning of everything else in the document. A durable power of attorney takes legal effect the moment it is signed. It requires no court declaration of incapacity. It does not wait for a medical determination or a judicial ruling. It has no trigger event. From the moment of signing the authorized party, Diana could begin restructuring accounts, transferring assets, and making financially irrevocable decisions on my behalf, without my knowledge or further consent. It was not a protection. It was the last piece of the financial layer of the plan, in the language of a protection. I took the document and began to read it. I read slowly. I paused at clauses. I moved my finger along certain lines. I looked up once midway through and asked Diana a clarifying question about the scope of the asset authority provision. She answered with the steady patience of someone who has been waiting for exactly these questions and has prepared for all of them. The impression I was providing was of an older man navigating dense legal language with care and some difficulty. The legal assistant made a small note. In reality, I had read this document 14 times. Frank had obtained a near-final draft through a channel he did not explain to me in detail, and I had spent 2 evenings with it until I knew every clause, every defined term, every qualified condition by memory, the way I had once known our company's operating agreement, not as something I was reading, but as something I had already fully absorbed and set aside. I set the document down at the end of the last page. "I have a few questions," I said. I asked them. Diana answered them. When I had no more, I reached into the left breast pocket of my vest and brought out both pens, setting the ordinary one on the table and holding the UV pen in my right hand. They were similar enough in appearance that no one noted the difference. I signed my name on the signature line. A clear, confident signature, the kind that looks like the product of a man who has signed a great many documents and finds the mechanics of it unremarkable. And in the same continuous motion, a single unbroken pass of the hand, completing the last stroke of my name and carrying through into the right margin of the signature page. I wrote in ultraviolet ink, signed under duress, "Fraudulent. A. Weston." Under the overhead fluorescent lights of that conference room, the margin was blank. I pushed the document across the table. Diana signed in the co-party space below my line. The legal assistant signed in the witness field. The associate signed in the second witness field. Diana looked up. She smiled. Not a composed, appropriate smile, a real one, the kind that comes when something you have worked toward with considerable effort and over a long period of time has finally resolved. I had seen that smile before on different occasions for different reasons. I recognized exactly what it meant. "Thank you, Arthur. I know this wasn't easy." "Of course," I said. We stood. We shook hands with the appropriate formality. In the lobby, we went in different directions without discussion. In the elevator alone, I allowed one deep breath. I looked at my reflection in the polished surface of the doors. Not relief implies the difficult part is finished. Not victory implies the outcome is secured. Something more neutral. A marker that the next step in a specific sequence had been completed and that the sequence continued. She had the document. She believed she had what she needed to complete the final stage of the plan. What she had was a piece of paper bearing my signature witnessed by her own legal team, authenticated by her own counsel with my handwriting. In the margin handwriting that would appear under a specific wavelength of light, in the middle of a room where that precise question would eventually be asked. A statement of duress and fraud in my own hand, dated and located by the document itself, signed in front of two people who had not known what they were watching. That was June of 2023. December was still 6 months away. I walked out into the summer heat and stood on the pavement for a moment. The document was secured. The recordings were in Frank's safe. The independent evaluations were filed and dated. The financial records were documented to the last transaction. What remained was the work of ensuring that when the moment arrived, every piece of it reached the right hands at the right time inside the right room. By October of 2023, Frank Harmon's conference room had become something I can only describe as an archive of a plan being systematically dismantled, every component of it laid out across the length of the table, cross-referenced, authenticated, and organized for presentation under the emergency rebuttal provisions of a hearing that had not yet been scheduled, but that both of us understood was close. Patricia Howe's final forensic accounting report occupied the first section. 14 months of documented transfers, 23 distinct transactions. A total of $3.8 million moved through Diana's Realty, LLC, to entities with no legitimate relationship to its real estate operations. Every transaction traced to its destination account. Every transfer amount logged with its date, its stated classification, and the discrepancy between that classification and the actual receiving entity. Frank set a yellow tab on the top corner. Recovery of the funds will require a separate civil action. The criminal court can order restitution, but the civil suit for actual recovery will need to be filed independently. We'll address that after the hearing. The cardiology section came next. Dr. Raymond Ellis had prepared a formal expert report on the pacemaker data from the October night, the accelerometer log covering the full 8-hour and 23-minute window, time-stamped and certified. His written annotation read, physiologically inconsistent with any degree of physical activity exertion or physical altercation. Complete rest state maintained throughout the documented period, corroborated by contemporaneous pharmacy records for the prescribed sleep medication. Beside that, the two independent cognitive evaluations placed directly adjacent to Nathan Cole's Alzheimer's assessment. Dr. Osei's report from September 8, 2022. Dr. Webb's report from September 22. Nathan Cole's assessment filed November 2022, documenting deterioration he claimed had been observable since August. Frank had drawn a single bracket around the three documents with a red pen and written one word in the margin sequence. He claims observable decline from August, Frank said. Two independent evaluations from September record performance at the 94th percentile for executive function and no indicators of any cognitive disorder. He had no formal patient relationship with Arthur Weston. He has no valid clinical basis for any diagnosis, and the observational timeline he asserts is directly contradicted by science. He did not produce and cannot contest in this room because he is not here yet. The digital section, the NAS footage, and full audio transcript authenticated by Raymond Stafford, a forensic digital analyst whose certification report covered the file metadata, the creation timestamps, and the chain of custody from the encrypted drive to Frank's office safe, logged October 2022. Arthur's signed written statement. His direct account of what he had heard through the living room window before entering the house was attached as a cover document, establishing his status as a contemporaneous witness to the conversation the recording corroborated. The power of attorney photograph came last. Frank had taken the UV photograph himself in this office with a forensic-grade lamp he had ordered in October, 6 weeks before today. The hidden notation appeared in the image with complete clarity, white against the gray background of the paper, my handwriting, my signature initial unmistakable. "I ordered the lamp before we knew the exact hearing date," Frank said. "We don't know when they'll schedule, but when they do, we walk in with the capacity to demonstrate this on the same day. Without requesting additional time, we won't be granted under emergency terms." In October, after 11 months of supervised visits without a single reported incident, Frank had successfully petitioned the court to modify the visitation terms. School events and approved public gatherings were reclassified as semi-supervised, no court-appointed observer required, provided Diana or her representative received advance notice of attendance. Frank had filed the notification for the December 11th winter performance 2 weeks earlier. It would be the first time in nearly a year that I sat in a room with Lily without anyone taking notes. He closed the final folder. "They built a strong case, Arthur. Genuinely. The fabrication is professional and the supporting structure is substantial. But the emergency hearing format is a two-edged instrument. They filed under emergency terms, believing it would restrict our preparation window. Every piece of evidence on this table was authenticated and secured before any filing date they can produce. Under emergency rebuttal provisions, we present everything at the hearing on the day, without the standard pretrial discovery process. Their structure becomes ours. I arrived at Hargrove Elementary School that evening at 6:30, 40 minutes before the program started, and sat in the middle of the auditorium while the rows filled around me. Parents in winter coats. Paper programs being passed along the rows. Children backstage who could be heard occasionally over the PA hum, talking at normal child volume with no awareness of how clearly sound travels before a performance. Lily was in the second row on the risers. Navy dress hair pinned back. She sang with the full, slightly effortful concentration of a 9-year-old, working hard to remember every word of something she had practiced for weeks. She did not look out at the audience very often. When she did, she found me. A small wave, quick not for show. "I see you. I'm fine. You're here." I waved back. I sat in that auditorium chair and felt for the first time in 2 years something I can only identify as fear. Not the fear of losing, I had managed that possibility into something workable over the preceding 12 months. A different kind. The fear of understanding how close I had come to never sitting in this specific chair, in this specific room, watching this specific child perform. Of having been, by November, someone whose legal classification would have made my presence here contingent on another person's authorization. I drove back to the rental house, set my alarm, laid my clothes across the chair. I placed the UV pen on the nightstand beside the lamp. By the evening of December 11th, 2023, the evidence was assembled, authenticated, and in Frank's briefcase alongside a forensic UV lamp that had been prepared for this specific use 6 weeks earlier. What happened next was no longer in my hands. It lived in that room, the one we had been building toward for 17 months. Frank called at 7:14 the following morning. I was on my first cup of coffee. He said 4 words I had not anticipated, 4 words that changed the nature of everything we had prepared, in a way that was, in fact, entirely to our advantage. The filing arrived at Frank Harmon's office at 7:14 on the morning of December 12th, 2023. He called me immediately. His first sentence was 4 words. She went ex parte. I set down my coffee cup. By 8 o'clock, I was in Frank's office. He walked me through the legal mechanics, which I want to describe here because they are the frame for everything that happened in that courtroom that afternoon. An emergency ex parte guardianship petition is filed when one party asserts that the proposed ward represents an immediate danger to themselves or to others in their care. The court may act on that petition, based solely on the petitioner's sworn affidavit, without hearing from the respondent first. A temporary administrative order is issued the same morning. That is what had happened while I was sleeping. Diana had filed the temporary order had been granted, and she held temporary authority over my affairs, pending a show cause hearing, scheduled for 2 o'clock that same afternoon. Voyons. They filed emergency because they believed it would limit our preparation window, Frank said. What they did not calculate is this. The emergency filing format they chose was the very format that gave us the floor. Under those rules, any evidence gathered and validated before the petition date could be introduced at the show cause hearing directly, no waiting, no standard disclosure calendar, no procedural delays. The clock they believed would work against us had already run in our favor. He paused. Every piece of evidence we have was authenticated before December 12th. This afternoon we walk in and present everything. On the day. Legally and completely. Their strategy became ours, I said. Precisely. Before we left his office, Frank mentioned one additional thing. 3 weeks earlier, he had filed a criminal referral with the Hargrove County District Attorney's Office submitting copies of the NAS recording, Patricia Howe's forensic accounting report, and Nathan Cole's fabricated medical documentation, along with the supporting chain of custody records. I didn't tell you at the time, he said. I didn't want it to change how you carried yourself. The DA's office has been conducting an independent investigation since then. At 1:45, I walked into the courthouse through the east entrance. Maggie was standing in the hallway outside courtroom 3 with our mother beside her, Eleanor, 88 years old, in her gray wool coat standing straight in the way that had been her default mode for as long as I had known her. "Did you bring everything?" she said. I touched my left vest pocket. "Everything." She looked at me for a moment. "Then go." Courtroom 3 of the Hargrove County Probate Court was smaller than I had imagined over the months of preparing for it. Judge Patricia Hale had been on the bench for 28 years and had the focused stillness of someone who had presided over 1,000 cases and had long since learned to read a room from the file before she read it from the faces. She was already seated when I came in. Diana and Sandra Price were at the petitioner's table. Diana was wearing a simple navy top hair pulled back, no jewelry. The presentation of a woman who understood precisely how she needed to appear in this room, composed, credible, and under a weight too real to dress carefully around. Judge Hale reviewed the file in front of her and spoke without looking up. "We are here on an emergency ex parte petition for temporary guardianship. Filed December 11th. A temporary administrative order was issued this morning, pending this show cause hearing. The court will hear the petitioner's case in full, followed by the respondent. Counsel, you may begin." Sandra Price stood. She was measured and precise, the opening of someone who had structured this argument carefully and intended to deliver it the same way. Was experiencing accelerating cognitive deterioration. A board-certified neurologist had documented the decline over 8 months of clinical observation. A behavioral pattern had been established. External memory aids. Physical coordination concerns confusion. An incident in October had resulted in documented injuries seen by an independent urgent care clinic. Lily, 9 years old, had been directly exposed to this deterioration in her primary home. Every day without a protective structure in place is a day Arthur Weston is at risk, and Lily is at risk. Diana testified for 31 minutes. I watched her the way I had always watched people in a negotiation, without expression, without movement, from a position of complete external stillness. She described the October night first. The suddenness of it, her fear. Lily in the next room. She described the months that had preceded it, the post-it reminders she had seen around the house, the concern. When she noticed he had switched to a different pen on his doctor's advice. The questions she had started asking herself about how he was managing. Her voice broke twice in the way that voices break when the emotion underneath is real, even when the structure built around it is not. "I love my husband," she said. "He built something extraordinary in his career. He has always been one of the most capable people I have ever known. I am not here because I want this to end this way." She paused. "I'm here because I don't know what else to do." Sandra submitted Nathan Cole's assessment as documentary evidence. When Judge Hale asked whether Dr. Cole would be appearing, Sandra said that he had been advised by his own counsel not to attend pending a separate legal proceeding. Judge Hale noted this on the record and did not comment further. She noted it in the way experienced judges note things that they intend to return to. Sandra submitted the power of attorney. Mr. Weston signed this document voluntarily in June before 2 witnesses. He read it carefully and asked clarifying questions before signing. That is not the behavior of a man unable to make decisions. It is the behavior of a man who in a moment of clarity recognized what was needed. When Sandra completed her presentation, she sat. Diana had been a strong witness. The case Sandra had constructed around her was coherent, documented, and delivered without the kind of obvious overreach that invites immediate challenge. Nathan's fabrications were professional. The behavioral record contained details that were real. The October clinic report existed. The power of attorney bore my actual signature. If I had not spent 17 months preparing for precisely this afternoon, the case presented in Courtroom 3 before 2:45 on December 12, 2023 was a case that a competent judge might have decided differently. Judge Hale looked to the respondent's table. "Counsel Harmon," she said. "Does the respondent wish to present?" Frank Harmon rose from his chair. He adjusted his jacket with the unhurried composure of a man who had been waiting for this moment for a long time and had no intention of rushing through it now that it had arrived. He said 4 words, "We do, Your Honor." Frank Harmon did not raise his voice. He moved through what he had to present, the way a surgeon moves precise without surplus, nothing present, that did not need to be there. He began with the power of attorney. "Your Honor, the petitioner submitted a durable power of attorney as evidence of Mr. Weston voluntarily acknowledging his own condition. Before that document enters the permanent record, we request it be examined under ultraviolet light." Sandra Price objected on procedural grounds. The document was already admitted. "Frank, the document is in evidence, Your Honor. We are requesting a forensic examination of an exhibit already before this court." Judge Hale, objection overruled. A handheld UV lamp came from Frank's briefcase, the one he had ordered in October, 6 weeks before Diana knew there would be a hearing. He held it over the signature page. The hidden notation appeared in the margin with complete clarity. Signed under duress. Fraudulent. A. Weston. The handwriting had been authenticated in advance by a forensic document examiner. Frank noted this for the record. The room was very still. Diana was looking at the page with the expression of someone encountering a contingency they had not considered, and are only now understanding they should have. Frank placed the 2 independent cognitive evaluations directly beside Nathan Cole's Alzheimer's assessment. Dr. Ossie, September 8th. Dr. Webb, September 22nd. Nathan's filing from November, claiming deterioration dating to August. He let the chronology stand for a moment before speaking. Dr. Cole asserts observable decline from August 2022. These 2 independent evaluations from September document performance at the 94th percentile for executive function, and no indicators of any cognitive disorder, each from a separate institution, with no connection to the other or to Dr. Cole. He held no formal clinical relationship with Arthur Weston. He has no valid basis for any diagnosis, and the timeline he asserts is contradicted by science. He cannot dispute in this courtroom today because he is not here. Sandra turned to Diana. Diana gave a small, almost imperceptible shake of her head. A private communication the court could see but not hear. Dr. Raymond Ellis took the witness stand. He explained the pacemaker's dual monitoring capability in language a non-specialist could follow: heart rate and the integrated accelerometer, both time-stamped to the second, synchronized to the manufacturer's server in real time. He placed the certified log before the court. From 9:47 in the evening to 6:10 the following morning, 8 hours and 23 minutes, the device recorded a continuous, resting heart rate between 54 and 62 beats per minute with near-zero accelerometer activity throughout. This is consistent with deep pharmacologically assisted sleep. It is wholly inconsistent with any physical altercation. Frank, can this data be altered after the fact? Ellis. It synchronizes to the manufacturer's secure server at the moment of recording. It cannot be modified by the patient, a physician, or any party thereafter. Diana stood from her chair, then sat back down. Sandra placed a hand on her arm. Frank said, "Your Honor, Mr. Weston will provide a brief statement regarding a conversation he directly witnessed at his primary residence." I stood. I described the evening in my own words. The walk cut short by rain, the voices through the living room window, the 4 minutes I stood outside and listened before opening the front door. The conversation ending when I entered. I sat down. Frank submitted the NAS audio file and full transcript as corroboration of what I had personally heard. He played the recording. Diana's voice from 14 months earlier in a room where she had not known anyone was listening. "He isn't a bad man, Nathan." Diana did not move. Her hands were flat on the table. Sandra Price had gone very still. 3 to 4 million after attorney's fees. "Is that the life you've been describing?" "Okay, we do it your way." 4 seconds of silence on the recording. The kind of silence that carries everything, and then, does the first part really have to happen? Diana stood up. "Stop." Her voice came out low, then louder. "Stop, turn it off. Turn it off right now." Sandra placed a hand on her arm immediately. Judge Hale looked up from the bench with the unhurried attention of someone who had seen courtrooms break before and had no intention of allowing this one too. "Ms. Weston." One phrase, completely flat. The room stopped. Diana sat back down. She pressed both hands to the edge of the table. She did not look at me. Frank said nothing. He let the recording continue. Once. After that, it is paperwork and patience. When it ended, Sandra Price said nothing for 30 seconds. She was looking at her client. Diana was looking at the table, not at the recording device, not at the judge, not at me. At the table, at nothing. At whatever you look at when the thing you were certain no one would ever hear has just been heard by everyone in the room. Sandra would later produce correspondence showing she had called Nathan Cole's office and received confirmation that a patient file existed in their system. The fabrication had passed professional verification. She had submitted documents she genuinely believed were authentic. The fraud had been sophisticated enough to deceive the attorney presenting it. Frank submitted Patricia Howe's forensic accounting report, last 23 transactions, $3.8 million, 14 months, every dollar traced to entities connected to Nathan Cole. We are not asking the court to resolve civil recovery today. We submit this as evidence of the scope and intent of the conspiracy before this court. Judge Hale called a brief recess. Frank's phone rang in the hallway. He stepped away, then returned and leaned toward me. "The DA's office has been investigating Cole since I filed the referral 3 weeks ago. They found 2 prior incidents. Different cities, same methodology, different victims. They have sufficient grounds to detain him." 40 seconds of silence from the bench felt longer. Stockton. This court notes. Judge Hale said that an emergency ex parte petition was used in what now appears to be a calculated effort to restrict the respondent's preparation window. Instead, It placed this court in the position of receiving fully authenticated counter-evidence under the emergency rebuttal provisions that emergency filings create. She looked at the documents before her. The power of attorney is stricken obtained under documented duress. Dr. Cole's assessment is removed from the record as fabricated testimony with no legitimate clinical basis. The emergency temporary order issued this morning is vacated. The guardianship petition is denied in its entirety. Full physical custody of Lily Weston is awarded to Arthur Weston, effective immediately. This matter is referred to the Hargrove County District Attorney for investigation of perjury fraud, under color of medical authority, forgery, criminal conspiracy, and child endangerment. Diana was escorted from the courtroom. She was saying something as she passed through the door. It did not reach me. Maggie was at the bottom of the courthouse steps. She put both hands on my arms and looked at me the way she had at every moment in our lives that required one of us to confirm for the other that the ground was still there. But is it over? I looked up at the December sky, gray cold, with the particular quiet of a Thursday afternoon. It's over, Frank called 20 minutes later. Nathan Cole had been taken into custody. The state medical board had issued an emergency license suspension. Sandra Price will face Bar Association review for failure of due diligence. I don't believe she knew Arthur. Diana deceived her own counsel. A pause. Lily knows you have custody. She doesn't know the rest. That conversation belongs to you in your own time and whatever pieces she can carry. I drove to Hargrove Elementary and signed the early dismissal form. The receptionist called down to the classroom. I stood at the end of the hallway and waited. Lily came around the corner at a pace that was technically within school rules and functionally a run backpack, bouncing jacket half trailing behind her. She stopped when she saw me. Dad, why are you here early, huh? I crouched down to her level. Early pickup today, little one. She studied my face the way she always studied faces, the same look she had given her pasta at 7 years old. The one that had, without knowing what it was doing, changed everything. Is everything okay? I put my arms around her. She smelled like pencil shavings, and the winter shampoo she had decided was her favorite 3 years ago, the one I had bought every month since without being asked. She pressed her face into my shoulder, then pulled back with the efficient practicality of a 9-year-old ready to move forward. Can we stop for hot chocolate? I stood and took her hand. Yes, I said. We can stop for hot chocolate. We walked out of Hargrove Elementary on December 12th, 2023, and I thought this is what I built all of it for. Not the company, not the money, not even the win. This. Right here. Her hand in mine and a walk to the car and everything that comes after. December 12th was only one day. What followed the arrest, the trial, Diana's eventual plea, the long, quiet work of rebuilding what had been designed to look finished, ended the way the best things do on a Christmas morning a year later, with a 10-year-old who had far too much energy at 7 in the morning, a dog who agreed with her completely, and the particular piece of a man who finally knew that everything he had waited for had been entirely worth it. I have told you one of those grandpa stories that does not arrive with a tidy beginning, because real life rarely does. The lesson I carry from all of it is not about evidence or legal strategy. It is simpler. I believe God places certain turning points in every life where we must decide who we are genuinely capable of becoming. December 12th was mine. My advice to you, do not do what I did for the first year. Do not choose not to know. When something feels wrong in the structure of your life, look at it directly. The cost of clarity, however painful, is always less expensive than the cost of deliberate blindness. Among all the grandpa stories I could tell you, this one carries the warning, I most needed someone to give me earlier trust that was never truly earned, can wear the face of love for a very long time. And the people who build plans around your vulnerability depend entirely on you never looking closely enough to see the blueprint. At the center of every family story is a choice: protect what matters most, or look away from what threatens it. What determines which path you take is not luck. It is attention, patience, and the courage to act on what you actually see. These grandpa stories exist because some things need to be said out loud for whoever needed to hear them today. And this family story, more than most, needed to be heard. If this family story stayed with you, leave a word in the comments. Share it with someone you trust. And if this is your first time here, subscribe because the stories ahead are worth coming back for. Thank you for staying with me to the very end. That means more than I can say. A note before we continue: some stories on this channel contain fictional elements constructed with care for educational and reflective purposes. If that is not the content you are looking for, we respect that entirely. Please find what speaks to you.